Hello and welcome to the Kenneth for Ken Law Office Legal Podcast, the NJ Laws Tube. And in this edition, we're doing a seminar for the Edison Police Department dealing with the major recent cases affecting criminal and traffic by the courts in the past year. And in particular, we look at what hearsay is, let's say, and there was a major United States Supreme Court case called the Crawford decision, which restricts hearsay. So, certain things are no longer admissible unless witnesses will appear in court. So, what about eyewitness statements to police officers at the scene? Are those admissible? And the answer is no. Statements by eyewitnesses are not admissible as an emergency investigation. That was the case of state in the interest of J.A. Now, what about statements made by kids to DYFS workers? Well, that's a little different. The Supreme Court in State versus Buddha determined a statement for a DYFS worker is admissible under the as an emergency. Also, the Supreme Court in case State versus Coder, C-O-D-E-R, indicated that a statement by a 3-year-old dealing with a sexual assault was admissible even though the child didn't testify and didn't remember under what's called the tender years exception. Now, oftentimes in the prosecution of cases, documents are attempted to be introduced into evidence, and a major type of document is certificates that a breathalyzer was tested. Are those documents admissible? And the answer is yes. State versus Sweet. The hearsay rules don't apply to breathalyzer certificates. And then the New Jersey Supreme Court in State versus Chun also held Alcotest certificates are admissible without having to go through objections due to hearsay. Yeah. New Jersey courts have for many years looked at cases where someone is found guilty of careless driving and speeding. Can a judge suspend someone's driver's license for speeding or for careless driving, even if the statute of careless driving or speeding doesn't mention suspension? And the answer is yes. State versus Moran, where they said that a judge can suspend a driver's license for a willful violation. Other cases determined by our courts deal with search and seizures. For example, let's say there's an invalid police warrant. Let's say, and the police arrest someone not knowing that the warrant was recalled. Does that require suppression of the guns or drugs found? And the answer is no. In Herring versus United States, the United States Supreme Court said those items would not be suppressed because the mistake was not by the police. Now, let's say it's a roadside case and someone's charged with illegal U-turn, but there's no testimony that the U-turn sign was properly placed and it's on a road, not a highway. Is that a defense? And the New Jersey court has found no, that's not a defense. The fact that there's a sign, that should be sufficient. The defendant would have to prove that the sign was not properly placed, and even if the statute says a highway, the fact that it was on a road, there's a rebuttable presumption the sign is properly posted, and that's State versus Smith. Now, New Jersey has a statute that's called unsafe driving, and for the first 2 offenses, there's no points. There's fines of over and surcharges of over $430. On their third offense, it's a 4-point ticket. But let's say 5 years go by. How many points is it? And the New Jersey Supreme Court just held that Patel versus NBC, there's no points if there's more than 5 years between the second and third offense. That's Patel versus Motor Vehicle Commission. See? Now, refusal to take the breathalyzer, or breath test, is a very serious offense. And back in 1987, the New Jersey Supreme Court recognized that sometimes people are confused between the Miranda warnings, you have a right to remain silent, and other warnings. And they recognize the confusion doctrine. Well, what if someone doesn't speak English? Well, the appellate division in New Jersey said, tough luck. a refusal stands even if the driver does not understand English. That's State versus Marquez. That there's no duty to translate the warnings to take the breath test into Spanish. Drug cases. Courts have looked at how to get the lab certificates. In New Jersey, there's a statute that says that if there's written notice to the defense counsel that they're going to introduce the lab certificate and no objection, the lab certificate gets in. What has the United States Supreme Court said regarding that? Well, the United States Supreme Court has said that and ruled that lab reports are not admissible in criminal cases. They have to bring in a lab technician. And that's Melendez-Diaz versus Mass. That was decided in 2009 by the United States Supreme Court. Other cases dealing with drugs, constructive possession. Is being in a car with large amounts of drugs where a passenger could possibly reach them, is that automatic constructive possession? In State versus Reeds, they said constructive possession is the decision by the trier of fact, the judge or the jury, not by an expert. But they have language describing, again, what constructive possession means. Our other cases that were decided by the courts deal with searches of commercial vehicles. So can a commercial vehicle be searched during a routine safety inspection without a warrant? And the New Jersey Appellate Division said yes. In State versus Hewitt, a commercial vehicle could be searched during a routine safety inspection, even because commercial vehicles are different than regular vehicles. DWI cases. The police are required to read what's called paragraph 36 to a defendant, advising them that they have to take the test. Let's say the police don't read the second paragraph. Is that a defense to the refusal? Well, the court in State versus Spell said that there's not an automatic dismissal of the refusal, but the appellate division cannot amend the refusal statement. That has to be done by the Motor Vehicle Commission, and that was State versus Spell. So they really didn't answer the question. We had other cases decided by our courts. For example, let's say warrantless searches. Let's say there's an unattended child. Can the police search the house to check on the child without getting a warrant or permission from a parent? And the Supreme Court said yes in State versus Bogan. A warrantless search of a house to check on an unattended child was permitted under what's called community caretaking, and that was State versus Bogan, B-O-G-A-N. Now, Miranda is where someone is advised of their right to remain silent. If they're not given their Miranda warnings, then the statements might not be admissible in a trial. Can a Miranda violation be asserted by a co-defendant? And the answer is no. State versus Baum, which was decided by the New Jersey Supreme Court in 2009. And lastly, let's see, can a school principal search a car on school grounds if they suspect criminal activity? And the answer so far is yes in State versus Best. That was an appellate division case. However, there's going to be a new decision to determine whether that's still good law by the New Jersey Supreme Court shortly. For additional information on recent cases, go to website njlaws.com. That's www.njlaws.com, njlaws.com, or call the law office of Kenneth Verkaman, 732-572-0500. We're located at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. And I'd like to thank the Edison Police Department for inviting me to do this program dealing with recent cases by the courts, and we invite other police departments in Central Jersey to have us discuss with their police departments and officers what other cases have been decided. Thank you and good luck.